Okay, here we go.
Okay. Welcome once again to The Law Matters. Hi, I'm Debbie Moraes, your host and moderator. The program has been created to educate, inform, and help you with the law matters because, as we say, the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources that'll help you decide whether or not you want to contact a lawyer. Perhaps will help you determine that you can handle some issues yourself. If you do need professional counsel, you'll be better prepared, and as a result, so will be the professional you select. Either way, our desire, of course, is to help you save time, money, and achieve better results. The Bazar & Associates law firm in East Providence continue to offer their insights and perspectives and facts on the legal issues that we tackle. And once again, we'd like to welcome and thank Attorney David Bazar.
Thank you, Debbie.
So today we're going to address contracts, how to review, prepare one, negotiate one, and also perhaps ask David for a few professional tips. Consumers and businesses alike will find this helpful, we think. We enter into contracts every day, whether for personal or business reasons, and some are written, some are oral, and in either case it's important that the terms of those contracts are fair, are properly drafted and reviewed, and are ensuring that they meet the intentions of the parties that are involved. That's often easier said than done, and so we decided we better tackle that today. Maybe you can handle some issues as a DIY, maybe not. So, David, I guess as a quick start, if someone hands you a contract, a vendor or whatever, are you supposed to assume right off the bat that that is gospel, or is that always just an opening case for discussion?
So I guess the question you're asking is that an offer to enter into a contract or a contract itself, and what does that all mean? So let's just go back one step first and talk about contracts and the importance that they serve in our economy and in any really economy. So in order for the economy to be successful, business people have to know when they enter into an agreement whether or not the agreement is enforceable. Can they go to court if the other side breaches the contract, and have a valid agreement that they can have a court enforce. And so it's a whole course in law school of what creates a legal contract and what goes into it. So what you presented to me is the beginning of contract law and contracts. What is a contract? It's an offer and then an acceptance. There's got to be consideration, and it has to be for a valid purpose. So when the situation you present to me is if we have two corporations or two businesses or two people who have equal strength in negotiating the terms of a deal, then if one company presents to the other company a document that they call a contract, until it's agreed upon, until that offer is accepted, it's just an offer.
And I think we should probably go through, as you had started to suggest, there are something like 10 points that are part of a contract. Let's hope we can go through some of those.
Yeah, we'll hit each as we go.
But when someone is handed a piece of paper, we hear that some are just looking at it quickly and saying, I couldn't deal with that, put it down, walk away. So I guess the question is, isn't that just an opening conversation rather than something that you are expected to just take a look at and sign on the dotted line as a go or no go?
So again, if we're talking in a situation where two people are negotiating a contract and there are terms to be agreed upon, and this happens throughout our economy everywhere. An example is you're selling a home and I want to buy a home. We may have a broker in between us helping to negotiate the terms, but all of the key elements in that purchase and sales agreement are subject to negotiation. The price, the closing date, the deposit, what's going to happen in the event of a breach of the contract, who's going to be responsible until the property closes for insurance, and who's going to bear the risk of loss, and all of these other items that can go into a contract, they can all be negotiated, as opposed to certain contracts where the consumer has very little bargaining power, and it's sort of a take it or leave it kind of thing, which then creates an issue in the enforceability of that. What am I talking about? Well, for example, we see these, and we've talked about these before, the click, I agree to these terms when you do something on the internet, buy something, enter into some kind of agreement with a vendor on the internet. You're not going to have an opportunity to negotiate the terms that are in those quote-unquote agreements or contracts. Therefore, there may be some enforceability issues for the vendor with some of those. You go to a utility, you're going to buy a cable or
Cell phone.
electricity or cell phone. Usually you go into Verizon, for example, to buy your cell phone, and here the salesman has a little tablet, sign here, sign here, sign here. You get a chance to read those, negotiate those, and say, well, I really don't like that term, that arbitration clause that says I have to go to arbitration if you breach the contract. Can you get around that? You can't certainly negotiate it because the salesman has no authority to negotiate it. There's no leverage to negotiate it. So that's why those things sometimes become the focus of a class action lawsuit or something along those lines, or then the enforceability of it when there is a breach of that contract.
So David, when we say some things should be a do-it-yourself, if you are ready to enter into a cell phone contract, you may have one page that tells you the price and a few details, and then 7 that follow it that are in mouse 4-point type that most people aren't going to read. You probably, as a lawyer, are going to say they certainly should. Do you? Do most? And what can you do about it, as you pointed out?
Well, of course, I'm going to tell you should read every single word and punctuation mark and all that, but you're right. Nobody really does. I don't think anybody really can. And even if you do, what can you do about it? So really, the big terms that you're understanding and negotiating in that kind of situation is what's the length of the contract I'm entering into, what's the price, what are my rights, what data usage do I get, that type of thing. Most people understand and will be aware of what they're buying because that's the important thing to them. All that other language that they have no control of, there's really very little they can do. It's really the choice, accept it or walk out. And you don't really have much more bargaining position beyond that.
In other circumstances where between two people or two businesses, if you see an extraordinary amount of legalese, would that tell you, I know you're a slightly biased opinion, if you see so much legalese, does that automatically trigger, I better get a lawyer's second set of eyes on this because I don't know what kind of risk I'm entering into or what repercussions if I sign, how costly this might be in fact?
So any contract where you do have the power to negotiate and accept or reject terms to it, you should probably have an attorney to at least either negotiate it for you or explain the terms to you before you sign it. And there's a lot of areas where you do have that ability. Contracts, as we talked about, for the purchase and sale of real estate. Prenuptial agreements, that's a contract. There are certain things that need to go into it. You definitely should have an attorney on both sides, the husband and the wife or the two spouses, have someone explain that to them and negotiate terms for them if they need to be. If you're in a business where you're trying to enter into an agreement with a vendor and there's some terms that can be negotiated, you certainly should have an attorney look at those for you.
Is it ever really possible for you to scrutinize a contract so that there really is no room left for interpretation or misinterpretation? I know you try to iron out as many details. How can anything ever be so tight and succinct and clear that there's no room to debate or litigate?
There can be documents that are better drafted than other documents.
Fair enough.
But even in the best of circumstances, there can always be something that one party or the other party reads differently and interprets differently and may be subject to litigation because of that. So a good drafted contract will eliminate a lot of that, but can I sit here and tell you that if it's done perfectly, there will never be an issue? I can't tell you that.
For those who wanted to do it themselves, the DIY people, and there are things that you can certainly look at online, off the top of my head, I think of one that says something must be paid in a timely manner. Is that something that you should automatically question by whose definition and what are the terms of timely manner? Are there certain watchwords or catchwords that you can give our viewers some red flags on?
Well, there are certain things that mean different things in different contexts. So the purchase and sales of real estate sometimes will include time is of the essence. And that becomes a very interesting and well litigated area. What does time is of the essence mean in that instance? Does it mean that a week's delay beyond the date that's in the closing document or in the real estate purchase agreement is a violation of time is of the essence? All of these things really pretty much are fact-driven, and it depends on the circumstances and the cause and all of those things that would create whether or not something violates the vague terms, pay in a timely fashion, time is of the essence, those types of things. But there are certain things that you can do to protect yourself. For example, spell it out, pay in a timely fashion. Give some repercussions in there if you don't. You must pay within 30 days, 2 weeks, 1 week, whatever it is. If you don't, then you will owe whatever the penalty is, 5% of the outstanding balance, or something that's reasonable but yet enforceable.
Completed work.
What does it mean?
What does that mean?
Again, you need circumstances or facts surrounding it. If we're talking about, for example, a construction contract or a remodeling contract, which may apply to more people, there's ways of spelling that out so that there's some context to the definition. Final payment due upon completion of work. If it's a type of situation that requires a municipal city or town inspection, you might say, I pay X number of percent of the contract or dollars at the rough inspection of electrical or plumbing or whatever. And then there are other inspections that come along the way, and there might be a final inspection if it's building a house. It might be a certificate of occupancy. That could be the definition that you use in place of upon completion of work, because the contractor might think completion of work is, I'm done doing anything here, whereas you might think it's, well, you didn't finish the job and I don't have a certificate of occupancy or whatever it is that you need to have a final inspection.
So if you're about to work with a business or a person who's getting involved with contracts, if someone is ready to write one, I understand there are 10 listings of things for capacity of parties, lawful consideration. How do you start to work with a client? Do you ask them to draft some notes of terms that they might think are important and then sit down with them, or do you just sit down with them and get a scratch pad out?
So those types of things you were starting to list out are the things that we all learn in law school.
Yes.
About what makes a contract enforceable or not. Some people will never even think about some of those things that go into a contract, such as you said, capacity. I used to teach law at a college level, and one of the most interesting things for the kids when I was teaching it, the students I should say, is capacity. And they loved the stories of these different types of cases that existed. For example, two people in a bar talking about the purchase and sale of a farm that one person owned, and they were back and forth for years and years and years, and they wrote out on a napkin, I, the seller, agree to sell, they used to use the term Blackacre, but whatever the property was, to the buyer for X number of dollars, and on and on. They listed out all of the critical terms that need to go into that type of contract, the price, the description of the property, and everything. So the seller, after he went home and sobered up and said, what did I do? I didn't want to sell this piece of property. The issue in that case became capacity, because they covered all of the terms that needed to be in that agreement. So the question then became, did the person have the capacity to enter into that contract? And capacity oftentimes deals with minors, for example. Minors can't enter into a contract, so the contract becomes voidable by the minor.
Inebriated?
So is this person inebriated to the extent that he didn't understand the key elements and terms that he was entering into? And the testimony in that case, it was a Southern case, is that he was as high as a Georgia pine. And unfortunately for him, my recollection is, and it really doesn't matter for our purposes here, but they didn't establish that his capacity was such that he didn't understand what he was doing because he was able to write out all of the key essential terms of that agreement. But capacity is a way of challenging whether a contract is valid or not. If someone's under a guardianship, for example, there's an assumption that they don't have the capacity to enter into their own agreements.
Would or might someone who is an undocumented immigrant, would they have the capacity if they're not to enter into a lawful U.S. agreement on our terra firma if
Yeah.
they're not legally here?
Well, I don't think that
Does
is
that
going to
help?
affect the capacity of the
Okay.
person to know what they were doing and to
Their
whether or not
status.
the agreement is enforceable or not enforceable.
Okay.
I don't think that is, it hasn't been, at least as far as I've seen case law, ever been an element of establishing whether or not that person would have contractual capacity.
It was interesting as I was reading just about nationality, jurisdictions, and who knows, maybe that'll be yet another.
Well, it may become. Where capacity could be an issue is, for example, someone who is incarcerated for a felony that they've been convicted of, and then can someone in prison, you know, through, if they have access to the internet or some other source, have the capacity to enter into a contract, and that's where there is case law that says that they probably don't have contractual capacity at that point in time.
Okay, and address one that people often talk about, maybe not everyone understands, lawful consideration. I think the term was heads I win, tails you lose. That's
Okay.
probably not lawful consideration.
So consideration can come in a number of different forms, and when you say lawful consideration, it sort of is pushing on two different areas. Whether consideration is adequate. So adequate consideration might be different from lawful, because then you're raising the issue to me, which I'll address, is whether the contract itself is lawful. So talking about adequate consideration, in an arm's length transaction, both sides have to give up something or get something in order for there to be consideration. In the cases that I used to teach, one of the most interesting one was where the uncle, say, promised the nephew to give him $10,000 if he refrains from using alcohol or drugs for a specific period of time, and he does, and then the uncle died, the nephew sues the estate and says, we had a contract and he owes me the $10,000, say, that he promised to give me. The estate of the uncle says, no, there was no consideration. Well, there was, because that person had the lawful right to drink alcohol or use drugs, so he gave up something that he could have otherwise done. That's consideration in that sense. So consideration doesn't always have to be something of measurable value to the other side. There was some value to the uncle, or he wouldn't have asked him to do that, but it wasn't monetary. So that's consideration. Did you give up something that you were lawfully entitled to do? Did you give up money? Did you give some value to the other side? A contract has to often cite consideration. That's why sometimes you'll see for $1 another valuable consideration that theoretically lays out enough consideration. Lawfulness is another issue in a contract, and it's interesting because the first reported case in Rhode Island, when they start, Supreme Courts keep written documents of their decisions, and then they were collated in the early 1800s in Rhode Island into reports. So Rhode Island Report number 1, the first case was about whether or not a contract was enforceable. And the contract was between two people, I think they were politicians, who bet on the outcome of an election. And the Supreme Court says that it's not legal to bet. First of all, a contract for wages, for gambling, may not be enforceable, but certainly not for the outcome of an election. And they talk about public policy and all these other things, and I think there's some interesting language in there to say, and of course, that would be an issue in Rhode Island, betting on an outcome of an election. But so that contract wasn't enforceable because the purpose they were entering into the contract for was illegal.
You certainly make a good case for why a lawyer is needed for all of these nuances, and some of them maybe aren't nuances,
Right.
but actually very big deals. What about the idea of free consent without coercion? I don't know if being drunk is considered coercion, but if someone had a knife at your throat, it certainly might be. So do you have some recourse, and is that something that's really written into a contract?
So it's not usually written into the contract. It's something that's used to either defend against the enforcement of the contract or to get out of a contract. And it really goes again to capacity, because in order for there to be a contract, it has to be freely entered into. So oftentimes you'll see attorneys where they're putting through, say, an uncontested or nominal divorce, ask the parties, did you sign this contract? Did you go through all the terms of it? Did you understand it? Did you enter into it freely and voluntarily? No one forced you or coerced you into entering into the contract. So,
Like marriage?
so like that, yeah. Well, you raise an interesting one, so I'll use that as the example. So in order for a contract to be enforceable, we say the person has to have the capacity to freely and voluntarily enter into that contract. So one of the areas where these things can sometimes get interpreted would be where there's undue influence, for example. And an example of undue influence, if you want to use marriage, maybe the 80-year-old husband or wife, whichever you prefer, who marries the 25-year-old spouse and starts signing agreements transferring property, or so it could be a little bit more into wills than contracts, but the same type of analysis. And did she have undue influence over the person, or did he over the person who's either signing contracts with them or gifting things or doing this type of thing? So in order for the contract to be enforceable, you can challenge it on the grounds of undue influence. You could also challenge it on the grounds of mistake or other issues that might affect whether or not the people knowingly and intentionally entered into a contract.
The way you're describing things, do I even need to ask, David, do you favor an oral contract, one that's not in writing?
So some contracts can be enforceable even though they're not in writing, others cannot. And it goes back to common law and the Old English rules of certain contracts needed to be in writing to prove their enforceability, because there are certain areas that were very precious and easily subject to fraud. And so it's called the statute of frauds. And some of the areas are the purchase and sale of real estate has to be in writing. A contract to enter into marriage has to be in writing. A contract to accept and pay for the debt of a third person has to be in writing. Why are these types of things that have to be in writing? Because they're easily become a he said, she said type of situation, and the courts don't want to try to enforce something where they don't know who may or may not be telling the truth, and therefore say, show it to us in writing. So the writing has to be such and sufficient to show what the agreement is, and it has to be signed by the party who is being charged with upholding or enforcing the agreement against. So for example, if you and I enter into the sale for real estate, a contract for this purchase and sale of real estate, and I'm the seller, and I sign the contract, then you can use that against me even if you haven't signed it. It has to be signed by the person who you're trying to enforce it against.
Good point. Good to know. If you were dealing with contracts and employment contracts, and you're serving as the person's lawyer, that would-be employee or whatever, how do you work with them? Do you end up having a prearranged fee? You don't know how long something might take. If you go into negotiations, there might be several iterations of a contract. You don't know the end of that story. How do you work with a client, David?
So it depends on the situation and what's involved in the negotiations. Most situations like that you're describing are probably going to be done on an hourly basis. Mm-hmm. If it's a lawyer who deals with that kind of area regularly and knows what he or she is going to have to do, they might quote you a flat fee, but it sounds more like an hourly basis kind of arrangement to me.
And can your client be helpful to you by doing research or homework or getting information that you would need and saving you time? Can they actually do that? They might actually have access to information.
Yeah, so by research, we're not talking about legal research. We're talking about gathering the information that needs to go into the contract. Perhaps. So I've dealt with a lot of these different types of situations. I did it for a client who worked for a large pharmaceutical company in Rhode Island, and he actually had to get out of his employment contract with that company to enter into one with another equally large company in another state. So he had all of the information based on what other people in his situation would normally see in their contract, and sort of it served as a checklist for us to go through and make sure, yep, we got that covered. We don't agree with this term in that, but we don't need that term because he's relocating and it's not an issue. Whatever it might be, it's a checklist of things that might be common to an industry that would be helpful for a lawyer to have to go through.
And in the relatively small amount of time that we have left, if you're thinking about negotiating contracts, I like this, not that, there's risk here, I want more money there, whatever it is, what are the most salient points that you could suggest that someone be aware of when they're going into negotiations, whether you're doing it for them or if someone's doing it for themselves?
Well, I suppose if I'm negotiating a contract for my client, I need to know what the most important terms of that contract are going to be for him or her. Is it the length of the contract? Is it the amount? Is it freedom to do other things? And it, of course, depends on what type of contract it is. So I think what I would do with my client first is to prioritize what it is that we're trying to accomplish. You know, there's a lot of different things that you can look at, but you need to know what your client's priorities are.
What gives you the greatest leverage when you're going into contract negotiation of some sort?
Well, it depends on your position and the rules that apply. So you could look at a contract negotiation, for instance, free agency for NFL players. Some NFL players may be free agents with unrestricted rights, and they can negotiate from one team to another, so they have some leverage because there's a lot of people who want their service. Another free agent in that same situation may have some restrictions on what he can and cannot do because of years of service and union contracts and so forth. So his leverage is a little bit less.
Do you have to go through a thorough listing of what would constitute wiggle room? I mean, you have to have a, theoretically, as the books say, you need to get to win-win. Do you try to plan for that, whether you're suggesting and coaching a client or whether you're doing it yourself? Do you plan for the wiggle room so that you can give someone some concessions, some places to move, and then a bottom line where you can't move from?
Well, that's certainly always a part of any negotiation, whether it's to settle an automobile personal injury accident case or to enter into an agreement to buy real estate. What you're willing to pay may be more than you're going to negotiate with initially, so that you do have some room to negotiate. That's what negotiations are all about.
Do you end up having a planned set of checkpoints with your client first so that you know how to negotiate for them?
You definitely have to do that, and you definitely have to know where's your client's bottom line, what is going to work for the client, what's not going to work for the client, and sometimes maybe there can be a little bit of a movement on what that might be, depending on what you might get on some other concessions in that agreement.
Good to know. If you're working with lawyers, not just your client, but another set of lawyers, is it more difficult to work with some lawyers than others? Do you really find that that's a case, or is it, I mean, rapport certainly matters, and
Sure.
I'm sure that you have good rapport
Right.
with your colleagues.
I don't really have a big problem working with any other attorneys usually, and I can say that what you may have to recognize is how that other person strategizes and what they do. So you know, I've dealt with this attorney before, he or she is pretty much straightforward, I know what they're doing, where the other ones you might have to be a little more cautious with.
So much to it. We hope that this has been helpful to you as we're discussing the ins and outs of contract negotiation. I think we could probably do several more sessions on it. Thank you for tuning in to The Law Matters. We hope you'll continue to. The Law Matters to you.